Good day, sir. I am Glaymar Sedilles, BS Criminology, 4th year, Section D. First question: define evidence and explain its scope. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Scope: the rules of evidence shall be the same in all courts, and in all trials and hearings, except as otherwise provided by law or these rules. What are the three kinds of evidence? Briefly explain each. Object as evidence. Objects as evidence are those addressed to the sense of the court. When an object is relevant to the fact and issue, it may be exhibited to, examined, or viewed by the court. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. What is prima facie evidence? Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. What is a dying declaration? The declaration of a dying person, made under the consciousness of an impending death, may be received in any case wherein his or her death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. What about statements uttered as part of the res gestae? Statements made by a person while a startling occurrence is taking place, or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res gestae. What is the order of examination of individual witnesses? Briefly define each. Letter A. Direct examination by the opponent. Letter B. Cross-examination by the opponent. C. Redirect examination of the opponent. And D. Recross examination of the opponent. Direct examination is the examination in chief of a witness by the party presenting him or her in the facts relevant to the issue. Cross-examination. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter, with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias, or the reverse, and to elicit all important facts bearing upon the issue. Redirect examination. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. Upon the conclusion of the redirect examination, the adverse party may be recross-examined by the witness on matters stated in his or her redirect examination. Briefly explain what is judicial affidavit. A judicial affidavit is a statement of a witness given under oath intended to take the place of their testimony in court during direct examination. An offer of compromise in criminal cases is an implied admission of guilt. What are the two exemptions? First, in quasi-offenses, or acts defined and penalized under Article 365 of the Revised Penal Code. Second, those allowed by law to be compromised. In order for evidence to be admissible, it must be relevant and competent. When evidence is relevant? When is evidence competent? Relevancy. Collateral matters. Evidence must have such a relation to the fact in issue as to the induced belief in its existence or non-existence. Competent of evidence. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law, or the rules. What is leading question? When it is allowed. And what is misleading question? A question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except A. In cross-examination, B. On preliminary matters, C. When there is difficulty in getting direct and intelligible answers from a witness who is ignorant, or a child of tender years, or is of feeble mind, or deaf mute. D. Of an unwilling or hostile witness, or E. of a witness who is adverse party or an officer, director, or managing agent of a public or private corporation. A misleading question is one which assumes as true a fact not yet testified to by the witness, or contrary to that which he previously stated. It is not allowed. When is circumstantial evidence sufficient to sustain a conviction? Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance, B. The facts from which the inferences are derived are proven, and C. The combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Distinguish burden of proof from burden of evidence. Burden of proof is the duty of the party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. What is standard of proof necessary in civil cases, criminal cases, and administrative cases? Briefly define each. Preponderance of evidence. How determined? In civil cases, the party having the burden of proof must establish his or her case by the preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issues involved lies, the court may be consider all the facts and circumstances of the case, the witnesses, manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their credibility so far as the same may legitimately appear upon the trial. Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof, excluding possibility of error, produces absolute certainty. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Define what are public documents. Public documents are A. The written official acts or records of the sovereign authority, official bodies and tribunals, and public officers whether of the Philippines or of a foreign country. Letter B. Documents acknowledged before a notary public, except last will and testaments. C. Documents that are considered public documents under treaties and conventions, which are enforced between the Philippines and the country of source. And D. Public records kept in the Philippines or private documents required by law to be entered therein. How do you prove and present in court private documents? By any of the following means. First, by anyone who saw the document executed or written. B. By evidence of the keenness of the signature or handwriting of the maker. Or C. By other evidence showing its due execution and authenticity. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four exemptions? Original document must reproduce. Exemptions. No evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed, or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact suit to be established from them is only the general result of the whole. And lastly, when the original is a public record in the custody of the public officer or is recorded in a public office. Who can become a witness? All persons who can perceive and perceiving can make known their perception to others may be a witness. When is an extrajudicial confession sufficient to sustain a conviction? An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti.